The public consumption will result in a class 3 misdemeanor, which is punishable by a fine of $500. And consumption operating a motor vehicle will be a misdemeanor offense, punishable, by up to 30 days in jail at up to a $500 fine. And subsequent offenses are class 1 misdemeanor. As it was mentioned earlier, the bill will direct funds related to the civil penalty to the Drug Offender Assessment and Treatment Fund. The committee will see that at the bottom there are some graphs that look familiar to many members. The Crime Commission did study decriminalization of marijuana. I lifted these charts, and this is something I will admit I would not have brought 2 or 3 years ago. But when we look at the disproportionate impact on sentencing, especially for second offenses on African Americans, it's startling. In fact, the Daily Press did an article this past year about it. Something I think needs to be done, and I think with the Crime Commission, they pointed out something's happening. Either it's geography or it is basically, I don't want to say profiling, but basically there's something going on. And when we are looking at what we're doing in suspending driver's license, and African American males on their second offense have a higher rate proportionally to incarceration versus their white counterparts, that does cause concern. So I just put this forward as just conversation. I realize that this is a significant change for us to make, but I'm glad that we have the opportunity to discuss it. So thank you.
Thank you, Delegate Mullen.
Thank you, Mr. Chair. Before we start to go into public comment and all the discussion that we're going to do, I would just ask if staff can sort of outline for us here on the committee the differences between the bills as we are evaluating them, since some of them are quite extensive.
Do you want to start with the 30 pages of italicized text in the one bill, or do you have where do you want to start?
Mr. Chairman, I was actually really able to boil it down to one piece of paper.
Okay.
The difference between some of the bills, the main differences, HB 2079, Delegate Herrick's bill, decriminalization establishes a $50 civil penalty first offense, $100 for second, $250 for third offense. Civil penalties, there's no license suspension involved with that at all, and it touches on the distribution of marijuana, and only that it adds a presumption that if anybody possesses less than 1/2 ounce of personal use, that it is, or of marijuana, it is for personal use. It is a rebuttable presumption. The difference between Delegate Carter and Delegate Herrick's bill, and they did a fine job of explaining what it does, but the difference in those is the penalties for illegal distribution of marijuana. Delegate Carter's bill creates a class 1 misdemeanor for the illegal distribution of marijuana without a license for greater than 2.5 ounces of marijuana to 5 pounds. Both of those bills change the penalty structure from what it is currently from a class 5 to a class 6 felony for the illegal distribution of, for Delegate Carter's bill, 2.5 ounces to 5 pounds. For Delegate Herrick's bill, it's 1 ounce to 5 pounds. Current law is 1/2 ounce to 5 pounds is a felony charge, class 5 felony with a maximum penalty of 10 years. Delegate Herring's bill, she explained, $250 civil penalty for the possession, criminalizes at a finable level public consumption, and includes basically a driving while smoking provision as well. There's no effect on the distribution during that, and there's still a loss of license for a juvenile, but not for adults. And Delegate Corey's bill is the same civil penalty structure as the others, the 50, 100, 250, but that goes to the literary fund versus the drug treatment fund that is created in Delegate Herring's bill.
Okay, thank you, appreciate that. All right, any questions from the panel for any of the respective patrons at this time? All right, anybody in the audience wishing to testify in favor, and we're doing it a little differently. So if you're in favor of legalization, you're obviously in favor of decriminalization as a secondary matter. So just come on up and tell us, I guess, your opinion on the related concepts.
Honorable delegates, chairman, I came here tonight initially to support HB 2373. I wanted to speak on this bill because I have personally seen lives of the people I care about and the people I care about, I've seen their lives destroyed far more by the criminal convictions that they've received from small marijuana possession than I have ever seen their lives affected by the consumption or use of marijuana. I wanted to zoom in a little bit on one of the 13,000 to 15,000 people that Delegate Carter mentioned. My friend's mother, who is a single mother with 3 children, once in her youth received a minor offense for possession of marijuana. Possession of 3 grams, less than $30 worth of marijuana, has cost her opportunities for housing, opportunities for jobs, opportunities for loans to even get her car fixed so she can drive to work every day. And I wanted to tell you this because she has been effectively homeless, living from motel to motel for the last 4 years. I have struggled to help her, my family has struggled to help her get back on her feet after this conviction. And I wanted to look you all in the eyes so that you know that there are real human lives being destroyed by these convictions. And of course, I don't need to tell you this is not unique. This is simply my own personal case. I believe if we wish to have a commonwealth with a truly restorative criminal justice process, we have to be at the forefront of this sorts of legislation. We must update our laws. I believe you all have a very positive opportunity to make change today, and I encourage you to think very deeply before you vote on this legislation. Thank you very much.
All right, anyone else wishing to testify in favor of any of these bills, please just come on up, line up, just don't be shy. Thank you, sir.
Hi, my name is Jesse Scatia. I'm with Virginia Normal. We support these bills. 7 out of 10 Virginians support fines, not crimes, for marijuana possession. Virginia increased marijuana arrests 20% from 21,637 in 2016 to almost 28,000 in 2017. So we would like to thank our delegates for fostering this conversation and for supporting common sense marijuana law reform. I just have to add a personal note. I've known so many people in my life, students, young men I work with at homeless shelters, my friends, veterans, who I've seen their lives derailed because of these laws. They're not criminals. I am not a criminal. We are not criminals for possessing marijuana. The day might not be today that we change these laws, but it will be a good day when we do change these laws in Virginia. Thank you all.
Thank you. Yes, sir.
Good afternoon, Mr. Chairman. My name is Ryan Wash. I'm the Deputy Secretary of Public Safety, and I just want to state that the administration supports House Bill 2370.
Thank you very much.
Good evening, Chairman and committee members. My name is Jenny Glass. I'm the Director of Advocacy for the American Civil Liberties Union of Virginia, and I'm here today representing over 24,000 members to urge that you support decriminalizing marijuana. Marijuana prohibition needlessly ensnares people in the criminal justice system. The prohibition imposes arbitrary, often harsh penalties for private conduct for which no criminal penalty is appropriate, and imposes all of the hardships of arrest and arrest record. The personal cost to those arrested is often significant and can linger for years. When people are arrested for possessing even tiny amounts of marijuana, it can affect their public housing and student financial aid eligibility, employment opportunities, and child custody determinations. Marijuana prohibition has needlessly ensnared tens of thousands of Virginians in the criminal justice system at a tremendous human and financial cost. I ask that you vote yes on the legislation that is before you, removing criminal penalties from civil marijuana possession at a minimum. Thank you.
Thank you.
Good evening, Mr. Chairman. Maureen Malin of the City of Norfolk, and as Delegate Herrick mentioned, our City Council has endorsed the decriminalization of marijuana. Thank you.
Thank you. All right, anybody in the audience in opposition to any of these bills, please come forward at this time.
Good afternoon, Mr. Chairman. Keenan Caldwell, representing Community Coalitions of Virginia. They're a statewide coalition made up of over 40 prevention coalitions that work on the substance abuse issue with youth. And they're kind of on the front line of addressing the opioid issue in Virginia. And they're in many of our communities doing the good work of prevention. They are opposed to all of these pieces of legislation for a couple of reasons that I'll just point out. Marijuana and its extracts are addictive, illegal Schedule I drugs according to the federal law and the DEA. Sensible laws to discourage drug use, not encourage increase or use or access to these harmful substances. If the penalties for possessing an illegal Schedule I drug are reduced, it removes the deterrent factor and reduces the perception of harm. Marijuana usage is linked to increase in both the exhibition of symptoms of mental illness and opioid misuse. And obviously we know that states which decriminalize marijuana progress to medical marijuana, then full legalization, and we create that slippery slope that we all know we are fast approaching.
Thank you. Yes, sir.
Lieutenant Gilbert with the Virginia Sheriff's Association. The Sheriff's Association has some concerns with this bill, and for those reasons they oppose it.
Thank you.
Good evening, Mr. Chairman and members of the committee. I think this is the fourth year I've been back here on these marijuana bills. I'm Regina Whitsett, and I'm
Not these. Go ahead.
marijuana bills.
Doesn't matter.
I'm the executive director of SAFE, we're the Substance Abuse Coalition in Chesterfield County, and I support Secova's position that was previously stated by Mr. Caldwell, and would like to add the following comments. Decriminalization and legalization of marijuana dramatically increased traffic-related crashes and fatalities, according to the Rocky Mountain High Intensity Drug Trafficking Agency 2018 report, and also the Northwest HIDA report. And I'm going to try to break this down with decrim first. If the decrim bills do pass, there should be substance abuse screenings that are critical to help people that could be using addictive substances, and also driver's license suspension should be required for anyone, including minors, for the possession of an addictive illegal Schedule I drug. Also, Delegate Herring mentioned the Virginia State Crime Commission study that was done back in October of 2017, and there was a report on the decriminalization of marijuana, a fairly lengthy study, and we ask that you adopt option number 1 and maintain the status quo, as a change would require serious policy considerations and needs further study. Now back to the legalization piece. There's been several mentions of revenues, and I can just mention here that any revenues collected from marijuana, whether they're directed to a fund for public education, for veterans, or for highway funds, they would not outweigh the negative impacts on public safety, the workplace, academics, health, and the natural resources that it would take to deal with the societal impacts of these bills if they should pass. And I will mention here also that funds from Colorado legalization, it was promised that it would help their budget, it would solve their school problems there, and it only contributes to 0.78% of their budget are now the funds that are coming in from their legalized marijuana. And also it was mentioned that the black market would disappear, and I urge, I think it was Delegate Carter that mentioned that, I urge him to go talk to the law enforcement officers in Colorado. The black market is alive and thriving, and actually worse, because now they can hide in plain sight of the marijuana industry. And also Delegate Herring mentioned the fact about sentencing for blacks. I would also direct you to look at the Colorado arrest reports. There is still, even with legalization there is still a high arrest number for blacks, so I don't know that it is specifically that they, it may be other issues. But I would say that one of the issues could possibly be that big marijuana, like big tobacco, puts the dispensaries and the pharmaceutical processors in disparate neighborhoods, in black neighborhoods, and so it's more accessible to that population. And lastly, I would like to say that the Virginia General Assembly has already passed laws for the Virginia Board of Pharmacy to regulate 5 pharmaceutical processors to grow, cultivate, and dispense marijuana oils for any medical condition here in Virginia. Those 5 pharmaceutical processors aren't even up and fully operational at this point.
Since they've been busy with the process of permitting, to my knowledge, the Virginia Board of Pharmacy hasn't even filed the required annual status report to the Virginia General Assembly. Therefore, I ask you, Mr. Chairman, and I ask the members of this committee, why aren't we waiting to see how the current Board of Pharmacy system works prior to expanding the black market or regulated market of marijuana in Virginia? Thank you.
Thank you very much. Yes, sir.
Chairman Michael Sack, Executive Director of the Virginia Association of Commonwealth Attorneys, and we have not reached a consensus on our reaction to these particular bills. We took a vote about a year ago when this discussion was coming up. I'm sorry, no, go ahead. Half the folks in our association want to leave the law the way it is. Half the folks in our association, roughly half the folks, wanted to get rid of the jail penalties, but still leave it as a criminal offense with just as a class 3 or class 4 misdemeanor. And of course, reference has been made to the Commonwealth's attorney for the city of Norfolk, who has taken a different position, and so that is also out there. So we don't have a consensus in that. But I would like to sort of repeat a comment that was made by Delegate Herrick as far as having a mature regulatory conversation about this particular topic. And I would add to that phrase, the mature regulatory conversation, objective conversation. It's interesting that just this past week, 2 articles have come out in major publications, one in the New Yorker, one in Mother Jones, discussing the mental health and the health aspects, and that it is not what it's been purported to be, as far as there are some mental health issues out there. There are health issues out there, and they are being sort of swept under the table. We need to have a mature, objective conversation about all these psychotic reactions to, by some people, not all, but some people have a psychotic reaction to smoking marijuana. We need to have a conversation about that. There's been some conversation as far as the incarceration rates. But interestingly enough, they weren't talking about simple possession of marijuana. It was just sort of in general incarceration rates. We have, the Commonwealth Attorneys Association this past summer did a poll amongst our members, and there are 120 elected Commonwealth attorneys in the Commonwealth of Virginia. And we did a poll. Not everybody responded to it, but a substantial majority of those folks did. An overwhelming majority of the folks who responded to that poll said that they are waiving jail on possession of marijuana, simple possession of marijuana charges. When people are talking about people being incarcerated on simple possession, it's just not true. There may be other crimes. They may be charged with possession of marijuana and possession of a Schedule 1 or Schedule 2 or whatever it might be. It might be possession of marijuana with the intent to distribute, which is in a lot of cases is a felony. It may be a lot of other things, but simple possession of marijuana, people are just not going to jail unless they are on probation, felony probation, and they test positive for the 16th time. Those are the folks who might be in jail. But we need to have a mature and objective conversation about DUID. DUID is very much became an aggravation and an aggravating factor when Colorado legalized marijuana back several years ago. Because unlike alcohol, where I can drink but not intend to get drunk, my understanding, my belief is people smoke to get high. And when you're high and then you get into a car, that is not the same as having a drink and getting into a car. And unlike alcohol and DUID, marijuana is not easy to quantify as far as what so we could say with alcohol it's a 0.08 per liter, whatever it is, but 0.08. We don't have that same objective measure for DUID as far as marijuana is concerned. We need to have an objective and mature conversation about edibles and the impact of edibles, or whether they're gummies or brownies or whatever they are. We need to have that conversation. We need to have a conversation about young people and what is the impact going to be on young people. Conversation about smoking in public, conversation about secondhand smoke, and a conversation about the revenue and the projected revenue. Because I could say anecdotally, when Colorado passed the legalization back several years ago, my daughter was living in Colorado, and we saw the pot shops. And you know who was frequenting the pot shops? The tourists. people who found it to be interesting, because the people from Colorado were going, they didn't want to pay the taxes, they were going to their regular dealer to get the marijuana at a cheaper cost. So we as Commonwealth attorneys are willing to take part in that mature regulatory but objective discussion over the coming time as it goes on. Obviously, we're not going to be able to get that done in a short session, but we're willing to take part in that objective discussion.
Thank you, you said. Okay. Members of the panel. Delegate Mullen.
Thank you, Mr. Chair. Would the lady from Virginia Safe please return to the dais for a moment? There's been a lot of discussion about Colorado in particular and their decriminalization scheme. And I think that there's a general consensus that, at least here on this panel, that Colorado got it wrong. And you were citing double-digit increases in traffic fatalities that occurred in Colorado. But, you know, there are a number of other states, including Connecticut, Delaware, Illinois, Maryland, Minnesota, Mississippi, Missouri, Nebraska, New Hampshire, New York, North Carolina, Ohio, and Rhode Island that have acted on decriminalization at this point. Do you happen to know what those traffic fatality statistics are in those other states?
No, I do know about Washington State, the Northwest Highway Report. There is data in there, and I know that the first year that they went up 48%, their traffic fatalities related to marijuana.
And wasn't it true that once they started to put significant investments from that into traffic education, that those leveled off and returned to the same levels?
No, I do not know that for certain.
Is it the case that that also occurred in all of the other states that I listed earlier?
I tend to disagree with that. I direct you to the September 2018 Rocky Mountain Highway Report, and there are still increase in traffic fatalities due to marijuana.
And that's in Colorado alone?
And Washington. I think both, if you look at both of them, the Rocky Mountain HIDA and the Northwest HIDA, you should see increases in traffic fatalities.
In the initial 2 years in Washington, but not in the subsequent years since?
I'm not certain about that.
Thank you.
Delegate Bell.
Appropriate time, I would like motions.
You have the floor. Delegate Bell.
Mr. Chair, so this subcommittee, as you know, because we were all on it, has taken the lead and has in fact written or edited the CBD oil bills in the last couple of years, and we'll probably have some of those this year as well. And I think that's an approach to which we have expressed comfort. This is, I appreciate Delegate Carter's, this may be the first time that he's brought it, but it's not the first time we've heard bills like this. And so I would be prepared to start moving on this bill. I don't want to cut off any debate.
Delegate Bell.
Mr. Chairman, I would move the PBI House Bill 2373.
There's a motion to PBI House Bill 2373. Is there a second?
Second.
All right. Excuse me.
The Delegate Carter has
All right.
if he wants it.
So you have 2 minutes if you would like it. You may take your picture while you're arguing. I'm happy to. I'll take it and send it to you.
No, thank you, Mr. Chairman. I would request that instead of PBIing this, we refer it to the Crime Commission. This is a very significant policy question, and I believe that simply deciding not to decide at this point without further study would do a disservice to the residents of this Commonwealth.
Thank you. Delegate Bell.
Just that we had referred this general idea over to the Crime Commission just a couple of years ago. Right,
And had that
we all sit on the Crime Commission, but I would, as soon as one of your people will retire, that I'm sure we'll find a spot. Mr. Chair, I would like to stick with the motion I have. Thank you.
Okay. Motion is to pass by indefinitely. Please cast your vote. All right, close the roll. That bill is PBI. Delegate Bell.
Mr. Chair, Mr. Chair, I would move to PBI House Bill 2079.
It is 2079. Delegate Heretic, you want to avail yourself. Okay. I mean, we've been here much much later than this, so I know you've referenced the hour, but this is not.
We got lots of bills after this.
Not the hour we're working on.
Long after you're at dinner, we will be here working on those bills.
All right, the motion is the PBI, House Bill 2079. Is there a second? Second. Please cast your vote. All right, close the roll. That bill is PBI. Delegate Bell.
Mr. Chairman, I would ask that we take up House Bill 2371 and I will move to PBI.
Second.
Okay. Any further discussion? Please cast your vote. This is 2371. This is the legalization. On the last one. Delegate Watts meant to vote on the last one, you meant to vote yes, okay. All right, close the roll. That bill is PBI. Delegate.
Mr. Chair, the next one is Delegate Harris, who's, I would move to PBI House Bill 2370.
Second.
Okay. Any discussion? Please cast your
Issue.
It's a test vote. It's a test vote.
Okay.
Strike that.
So we've been voting along these lines in a test vote.
Yeah, this is only one.
It says test vote.
I should know.
Okay.
Is the vibes.
Just cancel that vote. That was a clear motion. PBI. That's right. Okay, please cast your vote.
That's entirely different. It's an advertising.
Close the roll. The bill is PBI. Delegate Bell.
Mr. Chair, the last in this grouping is the House Bill 2644, Delegate Corey's bill.
State your motion.
I would move to PBI.
Is there a second? All right. Any further discussion? Delegate Corey, did you want to say, you have 2 minutes?
2 minutes.
Mr. Chairman, I am not going to take 2 minutes, but I do have a few remarks I'd like to make. I'd like to disagree with the gentleman representing the Commonwealth Attorney. I have been visiting prisons since last session, and the 300% increase in women incarcerated in Virginia is largely due to drug offenses.
Not this one.
Huh?
Not this one.
This one. Well, some of this, yes. So we can have that discussion offline, but I wanted to illustrate that this decriminalization would have a much wider effect than just relieving the person who has possession or the person who has purchased it. Because a lot of the women that I spoke to were supporting family members in their efforts to either purchase drugs and were caught for distributing when they gave it to their husband. So this is a complicated net, and a lot of people have been caught in it, especially women. Thank you.
Thank you very much. Okay, the motion is the PBI. Please cast your vote. Okay, close the roll. Thank you. That bill is PBI. Thank you, everyone, for a very thoughtful discussion. Appreciate it. not the end of the conversation, is it? Okay, we know. Thank you for being here.
So House Bill 1826, bill in relation to these bills, it has the word marijuana in the title, advertising bill, legal issues, I think all that is sort of transportation of time.
House Bill 1826 is going to come off our agenda. And, that discretion of the chair. Delegate Bell.
Chair, there are 3 bills left. If there was it's just those kids, it's Delegate Adams,
We do it the RS
me,
2172.
we went five for the day.
That five that they are after did I say by Great. Now we're just down to people who are required to be here by virtue of their job. Pretty much, right?
Are you trying to get rid of people?
Just a hint.
Selling coats?
597.
Mr. Chair, I would go ahead and start to go back to the amendment, so that's my concern. You know, I get your concern.
Okay,
I just want to, yeah,
tell
right.
us conceptually what you're trying to do, and then we'll see if your substitute still does that.
All right. This comes from the, okay, this comes from the Crime Commission. And this found, the Crime Commission found that commercial sex trafficking is a serious problem in Virginia. And there's confusion still about whether local social service departments can get involved, and if so, how to handle the cases when a child is identified as a victim of sex trafficking, that the sex trafficker is not the child's parent or guardian. So this bill proposes 4 key measures. It amends the code to clarify that sex traffickers do not have to be the victim's parent or guardian in order to avail themselves of social services, and that DSS be involved in the matter. I require local social service departments to conduct a family assessment if a report or complaint is based on the child being a victim of sex trafficking. It clarifies the jurisdiction of local social service departments, and allows the local social service departments to take emergency custody of children recovered from sex trafficking. Mr. Chair, my understanding is that there was an issue with the regulations of DSS, and so we had this substitute.
Is this it? What is this? I'm unfamiliar with this format. Okay. Is this all new language, is my question?
Yes, Mr.
Okay.
Chairman, it's new language. Some of it was in the bill already, and some of it's copied from 1506, but
All right.
that is going to be brand
So
new.
here's my question. This thing that I just got,
Yes.
is this the substitute?
No, that is a portion of the substitute for purposes of the substitute. We're drafting a bit on the fly this evening, but
Gotcha.
the substitute ultimately would strike the language from the current lines 62 to 71 of the bill
So
and replace that language with the brand new
This
language.
is 6271,
Yes, this is the new 62 to 71.
and then this is in addition to that, Jack.
So, Mr. Chairman, on the bill as it is, HB 2597, the line amendment that I've handed out of striking the shall and inserting the may on line 114, that takes place in the current text, and then they will be adding this new text to that.
Okay.
And we'll do that in the nature of substitute.
Okay, so 62 through 71. Okay.
Mr. Chair, I will,
Yes.
if I can just, I guess, do one at a time, like, move the line amendment on line 114,
Sure,
and then, do you want me to do that just as one single motion?
we can do it all together.
All right, and then, Mr. Chair, I'd like to strike line 62
So, go ahead. Tell us more about this Crime Commission bill.
Yes, Mr. Chairman. Colin Draper, Deputy Director with the Crime Commission. This is a Crime Commission bill. Basically, the basis of the bill was that there had been confusion in the field with DSS. Back in about, I believe, 2016, victims of sex trafficking were added to the definition of abused and neglected children. However, that doesn't everything else in that definition deals with parents or custodians being the individuals causing the abuse or neglect. It didn't cover situations where you may have a sex trafficker who's not a parent or custodian, and there was uncertainty in the field on how to deal with situations where a child is recovered. The person that they may be with is their trafficker, but that person is not a caretaker or a parent, and how does DSS get involved? So the main initial gist of the bill would actually be on the current lines 81 through 85 of the bill before you, which is meant to clarify that for a valid report or complaint of, for DSS to be involved in a trafficking case, the trafficker does not have to be a parent or custodian. And therefore it's crystal clear in the code that in this situation where a child is recovered from sex trafficking, if the trafficker is not a parent or guardian, DSS is still able to get involved in those situations.
So sort of begs the question, I remember when we discussed this, thinking that was sort of odd that they did, that wasn't the thing that they did, but I understand it was. So let's say it's something else, not sex trafficking, this is off topic. It's not sex trafficking, but it's also not the parent or the guardian. It's like they learn that a child is being molested somewhere else or something. Does DSS have any, is that a remaining gap where DSS still doesn't have any authority to act?
I believe in some situations, I know we have representatives from DSS here, but they have expanded the definition of caretaker slightly in other situations, and is it perhaps teachers I know that the caretaker definition has been expanded through regulation in certain instances. However, I'm not exactly sure the extent of the expansion.
I was just wondering if there were other gaps where, child protection.
There were none that we had specifically come across during the study, not saying that they do not exist.
I apologize. Go ahead, if I already cut you off, I'm sorry.
I'm not that. After that initial definition, what we then included, which is before you in the unique version of the substitute language, is essentially a new code section for sex trafficking assessments. Because when we have a situation where a trafficker, a trafficker is identified through this report or complaint, the current assessment structure deals with investigations into the family or family assessments, but there's no real unique response when a child recovered from sex trafficking where that trafficker is not a parent or guardian, and the investigation and the family assessment, while helpful, could be a bit intrusive if the family themselves was not actually aware of or involved in the trafficking. So the new statute essentially creates a preliminary step based off the family assessment, where if DSS does receive a report or complaint, this sex trafficking assessment would be conducted, whereby the DSS agency gathers information, and then if there's information gathered during that sex trafficking assessment where further investigation or assessments are needed, such as the full-blown investigation or the family assessment, then DSS can transition from this limited assessment, the sex trafficking assessment of the family, into a more full-blown assessment or investigation. And then the final provision,
Mr. Chair, may I just ask a
Delegate
question?
Mullen.
Thank you. I'm very familiar with the sexual abuse schema, but I'm not with the sex trafficking schema. I'm with the DSS side, I certainly am on the criminal side. Can you just tell us a little bit more about it? Because I think that's a very positive thing that we've been putting together, or been working with social services agencies to be able to develop.
Mr. Chairman, Delegate Mullen, the issue you brought up, the reason you're not familiar with it is because it really doesn't exist on the DSS side at this point.
Which is why we have this bill.
Yes, we're trying to essentially create something, a definition of sex trafficking was put into the code. However, a lot of the other provisions that tell DSS what to do when these victims are identified
was not added back in the definition, so we're trying to put a process in place right now. And Mr. Chairman, the final portion of the bill would be lines 113 up through 130, the emergency custody of the child. And that was put in to allow the local department to take emergency custody of a child who's recovered from sex trafficking. The situation often came up when we heard from law enforcement. It's 2 in the morning, recover a child from sex trafficking situation. We don't know what to do. DSS isn't sure if they can get involved. What are we supposed to do? So this amendment was made to the code to allow DSS to take that child into custody. The goal of that is to have the child taken into custody and then returned to the family as soon as possible, such that law enforcement is not left to wonder what should we do with the child when law enforcement may not really have the resources or knowledge in what to do with the child in that situation. So subsection C regards taking the child into custody, and then subsection D first to returning that child to the custody of the parent or guardian as soon as practicable, unless that would present some type of danger to the child's health or welfare. And it's our belief that if for some reason that child could not be returned for some other reason, such as danger in the home or they can't locate the parent, then that emergency order could be sought under the existing provisions of that statute to allow for DSS to retain custody of that child longer than is necessary to return.
Delegate Watts.
Thank you, Mr. Chairman. My question is on a basic issue that when we were dealing with child abuse neglect prior, we always knew who the parent was because it was a family member involved of some description or another. One of the reasons for this bill is that you may not know the family member. So I wonder if we don't, wherever you have, for example, line 2 of B2, protective and rehabilitative services needs of the child and family, if known. And there are a number of places where with the local department where the child resides with his parents or guardians, if known. The same thing at the beginning of D, in the event that the parents or guardians, if known, of the child reside in another jurisdiction. I think you have to provide for the fact that you cannot determine where the parent or parents are. And it needs to make sure that you don't require things that, absent being able to tell due diligence in finding the parent or parents. But I think you've got to provide for that.
Okay, that's a good point. I'm not sure if it would be whether it's known or not, or whether it's
Whatever.
No, I know what you're saying, but yes.
Sure. Mr. Chairman, Delegate Watts, Carl Ayers, Director of Family Services with the Department of Social Services. The only clarification, you certainly put if known in there, but if we do not know who the family is, we're not going to be doing this assessment. It would fall under the other custodial pieces, and the child would already be coming into custody. So what the Crime Commission is trying to do in this is, if we know who the family is and the child has been trafficked, then we want to make sure that the family situation is safe for that child to go back to. If we don't know the family situation, this 1506.1 is not going to apply, because the child is going to come into custody and they're going to go under 1505, which is your investigatory statute already. So you can add it to it, but in my opinion, it's probably not necessary, because this is probably not going to apply to those situations.
So what would be the avenue if there is no family? What you identified a different avenue of investigation or custody?
Yes, Mr. Chairman, if the family is not known, then we already have the ability, when the law enforcement contacts us, we would go out and we would remove that child and bring that child into care now.
Okay.
The situation that Crime Commission is trying to address is we know who the family is. And so we are able to go out and take emergency custody and then potentially make sure that that family is safe because of the issues that they are finding with children that are becoming sex trafficked, the runaway, the abuse and neglect that's occurring inside of that family.
Now I'm back to not understanding what the gap in services is. So what, somebody help me. So I thought it was that they find a 13-year-old girl involved in sex trafficking and call Child Protective Services and they say, that's not our thing. Even though we're Child Protective Services, that's not our mandate. So,
And Mr. Chairman, that's exactly what's happening. It's happening different ways across the state. And so
Okay.
the Crime Commission is trying to make it very clear.
I got you.
This is how it is, because we put the definition back in 2016 and thought it had been taken care of. What they found when they did their study is it's not being handled, and so this is an attempt to try to get clarity around the issue.
Okay. Okay. Does that satisfy you?
I think, well, it could, but I'm certainly understanding, but my problem, I guess, then is I'm looking at this new language, I assume. And I'm looking at it entitled Sex Trafficking Assessments by Local Departments, and I'm not sure that it makes the distinction of when this is triggered and when it isn't triggered, and making sure that you would turn to another code section under different circumstances, and I'm not understanding the clarity.
Sure, I think it would be in line 4, if you're looking at the new language, unless an investigation or family assessment is required pursuant to the other sections. And so the intent, so if you look at, it would be line 4, these aren't numbered, but it would be line 4 of your new language that doesn't have numbers, so count down your 4th line.
5.
4.
Oh, 5, okay, so sorry, 5. And it starts with unless an investigation or family assessment is required pursuant to
Do
the
you
other
have any
provision of
other
law.
provision of law, can you possibly direct specifically what statute one should use?
But certainly not. That's called.
There are 2 other provisions. The family assessment would be this 1506, and the investigation is 1505. So we could direct to 1505 or 1506, which is the specific reference to that either investigation or the family assessment. But
I would feel more comfortable if you did, so that the local departments are very clear, it's either this or it's that. Under that, unless, because any other provision of law, the social services department is sitting there and they're not sure about criminal law, where they're supposed to go. This has just not been their purview.
We just
So
don't
be
want anybody to
specific
say-
about where they turn.
We don't want anybody to be able to say that's not our job.
And the only reason we had used that, I believe that language appears in the current 1506 on line 58, the unless and under. I don't know, and I have to consult further with DSS, if there's other provisions of law that may trigger other responses other than the family assessment and the investigation that are currently referred.
Pardon me, if you only have the 2. So we have a differential response system. You have either an investigation or a family assessment. So pursuant to 1505 or 1506 would cover exactly what you're talking about.
That's fine.
Okay. Anybody else who would like to testify, please come forward.
Mr. Chairman, Camille Cooper with Protect. First, I want to say that the need for this is entirely my fault.
Okay.
So I'm very happy.
So many things.
So many things are my fault.
And God bless you for that. Yes, ma'am.
I'm really pleased with this language, and it looks very complex, and it looks like a lot of language to digest, but it actually makes a very small technical fix. And that was, our concern was that if if every single sex trafficking case was sent into family assessment and the family was not involved in that sex trafficking, there would be 2 unintended consequences for that. One, under the administrative code, social workers then have to notify the sort of the target. And we don't want traffickers notified, right? We're not going to include them in this family assessment process. And then 2, if it was a family that was not involved in the trafficking itself, it creates sort of a cloud of suspicion over this family now that they might have been, and that's not fair to that particular family when what they're doing is trying to recover their child, right? So there were 2 very small, very limited circumstances that if you moved it just into a straight family assessment track, that would be an unintended consequence. So what we all discussed and agreed on was that really what needs to happen for DSS is there needs to be a 3rd track, which is a trafficked youth assessment track. And that's what this is for. And so that's entirely my fault. I want to go back a little bit to give the committee a little context. A little less than a year ago, we put together a cabinet briefing for the governor's cabinet and briefed them on what is the sexual abuse to prison pipeline. And girls are being pushed into this sort of criminalization, and it's having a very harmful effect, because not only are girls sexually abused, and then they end up being trafficked, and then they end up being criminalized for it, which sort of exacerbates their trauma. It creates a situation that's very hard for them to get out of, and that's what we're trying to remedy. So what this bill does is it creates a clear path for youth that are trafficked to not be criminalized and sent into the criminal justice system, but it still allows the state to take custody of them and get them off the street, get them away from their trafficker, protect them, and get them into services. So this is really the only option, and from our perspective as an organization, this is the single most important child protection bill that the General Assembly has this year. It's really important to us, so I would hope that you would support it. Thank you.
Thank you. Aye. Aye. Everybody? Okay, somebody make a motion. All right. We love it. This is a lot of, I mean, we remember, I mean, when they were working so hard on it in the crime commission. Yes, sir. I mean, we're trying to pass this thing, but go ahead. Okay.
I'm not trying to, okay. Just to point out that under subsection D, that last, it allows DSS to take the child and keep them from the parents with no court oversight. Any other time where the child is taken, there's a procedure, and it's in section A of that same section, where the court can have oversight over going to JDR court, obtaining an emergency removal order. Just wanted to point out the distinction between the two, if the committee wanted to pick that up.
Is there a reason why that's the case?
Yes, Mr. Chairman, we intentionally not included court oversight at that point because we wanted DSS to have custody and return the child to the family as soon as practical. We weren't intending to DSS to keep any longer than needed. However, if they do need to take custody of the child, then they could proceed under, we believe they can proceed under A.
Mr. Chair.
I would
just ask the question of staff, in those emergency removal hearings, don't you have to give notice to the parents anyway?
You do, and I just, my issue is in reading section D, since it doesn't refer back to the emergency removal hearing. It's in a separate section from A, which specifically refers to the emergency removal hearing. I have a concern that that's going to be interpreted that you don't have to do that in these cases.
Delegate Watts.
Separate subject.
Okay.
I wanted to move the amendment on this language, striking any other provision of law and insert the proper code sections.
I don't know where we're going.
I'm in here. It was a point that I raised before, and the answer was rather than the generic or any other provision of law, it would be pursuant to whatever code sections were cited under 1506 and something else, so that you're directing the DSS staff people to go to the proper circumstances of that child that's been trafficked.
Okay, and just to be clear, I don't know where in the text you want to amend.
I am up here or in.
Okay, so she is on line 5 of the handouts. Let us never do this again. I know you have short notice. On line 5 of the handout. And what do you put in? So strike what?
Any other provision of law and insert specific code sections of the alternatives that you would do unless, when an investigation or family assessment is required. And they cited them, and I just want to amend that.
Are there any stylistic reasons why we should reference specific code sections, considering it might be changed in the future or whatnot?
So we frequently reference it, because I think we can do that now, it's fine.
So, and those specific code sections would be with respect to the,
It's to the, Mr. Chairman, to the investigation required pursuant to 63.2-1505, or a family assessment, actually is 63.2-1506.
okay, does that capture everything we're trying to reference there? Those would be the, quote, other provisions of law, would they not?
Yes, I believe just be 1505, 1506.
Okay. We're not there yet. Okay, to adopt, we need to adopt that amendment. All those in favor say aye.
Aye.
Those opposed, those amendments are adopted. Is there, do you want to say something else?
No, no.
Okay. There's a motion to report as amended. Please cast your vote. Okay, close the roll. Thank you. Good work, everybody. Appreciate it. Delegate Bell.
Delegate Adams has a bill on it, got a bill over time.
Delegate Adams, do you want to go first? Yes, Your Honor. I like it. Go ahead. Delegate Adams.
House Bill 2452. This bill is also on recommendation of the Crime Commission. It amends Virginia Code Section 18.2-456 regarding contempt of court to specifically add a subsection for failure to appear. As members of the commission will recall, the study indicates that this is the current practice. Judges across the Commonwealth charge under this particular statute, but there's not a way to track the actual charges for failure to appear because the statute allows for the summary contempt in other situations. So this enumerates it in a final paragraph, number 6. The bill also amends another place in the code under Title 16.1 where contempt of court can be added and specifies that if it is for failure to appear to make that charge under 18.2-456. So it's a way to concentrate the places by which failure to appear may be charged. The intent in doing it this way is to make as small a change in the actual process. As the study indicated, there's not a problem with due process or notice or anything like that. It's just a way to track it.
Just a lack of data as to
Yes.
who's not showing up for court.
You were concerned about the pretrial procedures and services may be at risk.
Okay, thank you. This helps us track why people are being held in contempt.
Yes, sir. And lastly, I believe the council may have an amendment he's suggesting, just to be clear. Law currently requires that all failure to appear must be willful. If criminal, and so the suggestion, I think, is to add the word willful before failure on line number.
Or is that really, is that, it says willful everywhere?
19.2.128, which is the failure to appear statute, says willful, and then case law under, what's currently being proceeded under, which is number 5, the case law requires it to be willful.
Huh. I bet 90% of it is not willful. It is something like that. Some other word to describe the lack of concern.
Mr. Chairman, I think willful is being interpreted very wrong.
Willful ignorance, maybe.
Willful
Maybe we should do
ignorance
that.
counts as well, I think under the statute. But that is
Yes,
what-
there's an inference, Mr. Chairman, that it is willful if notice is proven.
Okay, gotcha. Okay, all right, so we're just trying to be consistent.
The reason I bring it up is I don't want somebody to say that it was intentionally left out in that statute.
Okay. There's a motion to, yes.
Oh, just ask a quick question, staff.
Of course.
One of the things that I've certainly seen a lot, particularly in circuit court, is a race to the judge to see if you can plead guilty to the misdemeanor before you get indicted on the felony. This doesn't seem to affect that in any long-term way. I just wanted to make sure that that was the case.
The language says that it doesn't affect any prosecution under 19.2.128.
Thank you.
Mr. Chairman, I move the amendment.
All those in favor of adopting the amendment, say aye.
Aye.
Those opposed, the amendment is adopted.
Mr. Chair,
Delegate Bell.
hours late, sometimes we have mistakes and hours late. If I could ask staff, I'm having trouble putting these two in order. What we want to do is not change it. We don't want to leave it out if it was in, we don't want to put it in if it wasn't. Does putting the word in change it? In other words, I don't want a bunch of people next year to say this was a very important policy decision we made if we put the word in where it had been before, so now we want it to be willful, and all of a sudden,
Mr. Chairman, I don't believe it changes the meaning of what is current law. As I said, 192128 does include the word willful. It says whoever having been released pursuant to this chapter or 192319 or on a summons willfully fails to appear before any court. It is in there, and also it's not, the word willful is not in section 5 in the statute, but it is in the case law that it is required to be the elements of a violation of section 5. The last element that the court notes is willful disobedience to process. And they use the word willful in the statute.
Report. There's a motion to report. Is there a second? Any further discussion? Anybody want to talk about this? All those in favor, please cast your votes on the electronic voting board. All right. Close the roll. That bill is recommended to report. Delegate Bell, I believe we have the last bill.
okay, so it's about 10 words. I would like you to look at them. House Bill 2666. And this is coming out of the Deeds Commission, not the Crime Commission, so you guys have not seen this before. The issue was, we believe that police can sometimes divert someone out of the criminal justice system if they see them and identify them as being mentally ill, they take them to TDO rather than an arrest, that kind of thing.
I'd like the record to reflect it. Delegate Bell just said divert people out of the criminal justice system.
And so, there's a gold standard called CIT training, which is extensive and expensive and will be the aspirational goal probably for the rest of our lives in terms of how much training they get. But we don't have to let the perfect beat the good. And so one of the ideas that
Line
came out-
161,
Yep.
if you're looking for it.
Yep. And it just says, as part of the training, we will include, and again, the notion is that this will be less than the 40 hours, but more than they're getting now. You know, we like it. Now, the specific words, there's nothing magic about them. We are visualizing, at least I am, the guy who gets in trouble every 6 weeks, every 8 weeks. But the new officer may not know it. That's the goal. And the thought would be, there may be occasion where mental health referral makes more sense than just a lockup. So
This is K, little K
Okay.
there, and that refers back up to training standards.
Training standards, and it says sensitivity to an awareness of persons experiencing behavioral health, which is mental health, or substance abuse crises, including chronic homeless inebriates. The second part, I don't know that we need. It's a little very specific, but I was tracking some language from.
It is now.
It's just like horrible bosses. I don't know that we need homeless. I don't know. Kind of this came in as a organized thing. I mean,
There seemed like a better way to say it.
we have chronic homeless inebriates, and I think really we mean just chronic inebriates, or even just, you could leave it to simply substance abuse crises, which would cover.
Do we need the final clause?
I don't think so.
I don't think so either.
That's what I was saying. It was given to me as a whole, and I literally was swapping notes with staff. I think it's already covered by the substance abuse crises. I mean, if you're a chronic inebriate,
Well, then, with permission, I mean,
please.
make a motion to strike the final clause.
And addressing it with the comfort level, having lived through this and with Delegate Bell, I guess that it's behavioral health and substance abuse crisis, which typically lead to homelessness, because homelessness has been a major focus of the Deeds Commission as leading to everything else, but I don't think, and I'm thinking out loud, that it was ever looked upon as something that wasn't also part of a chronic mental illness that needed to be managed, and homelessness exacerbated the situation. So having thought out loud, I guess we can take it out, but the Senate may have its will.
That's right. I don't know that it does harm. It just overemphasizes one piece of it if you do that. So,
All those in favor of that, striking that language, say aye.
Aye.
Those opposed? All right. Amendment is made. Anybody in the audience want to testify? Everyone's still home? There's a motion to report. And a second. Please cast your vote. All right, close the roll. That bill is recommended to report. our staff, do we have any additional bills to consider today? Okay.
Mr. Chair,
Delegate Bell.
can I do that thing where I ask
Delegate
people
Bell
what
is
they want
going
us
to
to do?
do some stuff now.
All right, so everybody, we dealt with 27 bills. It took us a little over 4 hours. The issue was we got off the floor so late. We actually did okay. How early do you want to go home on Friday?
Sort of.
12:30.
I'd like to do by 3.
Okay. I'll do fewer than these bills, although Mr. Chairman, you know if we'll go in early, get out of there early, probably not. Because the Friday morning committee is going to start meeting.
I don't know.
Okay. I won't do this long.